Good morning, friends. My today's topic is remission policy for the convicts. This remission policy exists in our papers or on legal record due to Article 72 and 161 of the Constitution of India, and also the provision under Chapter 32 of the CRPC 1973, through which suspension, remission, and computation of sentence of convicts can be done. If we go by Article 72, it empowers the President of India, and Article 161 empowers the Governor to grant pardons, suspension, remit, and compute the sentence of the person convicted of any offense. The sections 432 to 435 of chapter 32 of the CRPC talks about the procedure for the suspension, remission, and commutation of sentences. So we can say that the state can prematurely release convicts under its remission policy, keeping in view good conduct, reformation policy, period of sentence which the convict has undergone, and also the health issues of the convict. What it is also true, if we go by the past incidents, sometimes governments misuse this power, so there should be check on it. The main objective which we can achieve through this remission is to take into consideration some aspects of the case which do not arise during proceeding in a court. Sometimes few aspects are not put before the proceeding of the court of law, and the person is convicted. But when the executive came to know, then the only solution is that the executive can show the convict some merciful behavior by way of remission, suspension, or computation. What is done in remission is the duration of the sentence is reduced without changing its nature of sentence. I mean to say the prison is released sometimes conditionally or sometimes without conditions. And as far as law is concerned, he is a free man after he is released on under this law. And if he is released conditionally, if he breaches any of the condition of remission, then his remission can be cancelled, and the convict would have to serve entire term for which the convict was originally sentenced. If we go by the section 432 of the CRPC, the state has to seek the opinion of the court which gave the sentence, and also it calls for the court concerning that convict from the relevant court. Then the state can decide whether to grant or reject the application for remission. So it means the accused, the convict has to give an application for remission on which the court applies its mind, government applies its mind. So the state has executive functions. So this can be called as an executive action. And the law requires that it should be ruled fairly and it should not show any arbitrariness in its action. That's why the amendment was done into the CRPC and section 433A of the CRPC was put into this through this amendment, which restricts the power of the president and the governor. So they cannot compute that sentence to less than 14 years of life imprisonment. If we go by Article 72, the president has the power to grant pardon, reprieve, respite, or remission of punishment, or he can suspend, remit, or compute the sentence of any person convicted of any offense in consultation with the Council of Ministers. As we already know that the president has to do the things only after consultation with the Council of Ministers. And on the similar pattern, Article 161 of the Constitution of India confers power on the governor of the state. So the application considered by the state, and if it is denied of remission of sentence, it will mean that prisoner would have to live in prison till his last breath without there being any hope for free escape. No doubt, the convicted has no fundamental right of remission or shortening of sentence. But the Article 20 and 21 of the Constitution, which is there keeping in view the constitutional safeguard granted to convict, the state has to exercise its executive power of remission, keeping in view each individual case and other relevant factors. So, the exercise of power of remission and releasing a prisoner on remission is not an act of charity or compensation, but it's a state's legal duty which is required to be performed, keeping in view the safeguards in Article 20 and 21 of the Constitution. So, if the prisoner has earned remission based on his good conduct in the prison, so it becomes a legal duty for the state to perform, and it should have to consider the application court. The power of pardon under Article 161 cannot be exercised in a manner which is not provided in the scheme of Constitution. As the Constitution is based on division of powers. So, if the judiciary has performed its essential function, then the governor should not take away that effect or modify its effect so that the essential function is become, you can say, it nullifies the judicial mind of the judge. It should not be done. So there should be balancing that. If there is in during judiciary, some facts has been kept beyond the eye of judiciary and came later to be in the knowledge of state that it can use its power, but not to nullify the judgment. Coming further, supposing a life convicts the right to ask for remission of sentence under the law, that can be used that was prevailing at the time of conviction. So the later on changes just to oblige a person heavyweight, having political background should not be done. That will erode away this constitutional provisions and give bad effect to society. And this is happening due, due to some political background till today, which you are reading in the paper. I need not to discuss that. So we can say there must be a limitation on the states when they are using their discretionary power to release the convicts, and particularly who are who have committed heinous crimes on women, children, murder of the whole family. So these are the things the state is duty bound to keep in view while giving remission. This is all about this on the remission sentences. So you might have taken my views, what I want to say. God bless you all. If you enjoyed a lot, then please subscribe. Otherwise, it's okay. Thank you.